Good afternoon and very welcome to this SNS webinar that we will dedicate to learning more about and discussing the Digital Markets Act, which is the European Commission's proposal on how to regulate the large online platforms, the so-called gatekeepers, in order to create a fairer business environment as well as increased consumer choice. The Commission submitted the proposal, also known as the DMA, in December last year, and it is now being reviewed by the European Parliament and the Council. What are the strengths and weaknesses of this proposal? If implemented, which effect would it have on competition and innovation? And how likely is it that it will be adopted? These are some of the questions that I hope that we will be able to shed some light on in the coming hour. We will start off with Björn Lundqvist giving us an overview of the proposal from a competition law perspective. Björn is Associate Professor of Law and Head of EU Law at Stockholm University, as well as one of the authors of SNS Economic Policy Council Report 2021, Digitalization and Competition, which I highly recommend if you haven't already read it. After that, Professor Rupprecht Podszun will share his view on the proposal, as well as putting it in the context of other models of intervention into digital markets that have been implemented or are underway. Rupprecht is holder of the chair for civil law, German and European competition law at Heinrich Heine Universität Düsseldorf, as well as director of the Institute for Competition Law at the same university. After Björn and Rupprecht's lectures, we will invite Håkan Hillefors and Pamela Hansson to join the conversation. Håkan Hillefors is Deputy Director General and Head of the Division for Market and Competition at the Swedish Ministry of Enterprise and Innovation. He will tell us what he can tell us about the Swedish position and how the Council's process of reviewing this proposal is going. Pamela Hansson is a lawyer and partner at the law firm Kastell. She has some 20 years of experience with the competition law. Prior to joining Kastell, she worked on antitrust and state aid cases at the European Commission, mainly within the telecommunication and media markets. A warm welcome to all the four of you. And also a warm welcome to all of you who are listening and watching this webinar. I encourage you to join the conversation by writing questions in the Q&A function, and you can do that whenever during the session. I will pick them up after each speaker or in the final panel discussion. If you prefer to pose your question orally, you can indicate this by clicking the raise hand function, and that will preferably be done during the final panel discussion. My name is Ilinka Benson. I am Deputy CEO at SNS, and I will moderate this webinar. And now I would like to leave the virtual scene to Björn. Please, Björn.
Thank you very much, Ilinka. I should also share my screen. Here we go. Yes, as Ilinka told you, I will present the proposal for Digital Markets Act, eller rättsakten för digitala marknader, som jag tror den officiella översättningen är. But I would do it from a competition law perspective, since the Digital Markets Act have some, it's been an act, or the proposal is meant to be pro-competitors, creating competition on the European market. And as Ilinka said, the proposal was put forward in December of 2020, and then the European Commission had proposed a sector-specific regulation for large platforms, so-called gatekeepers. And to become a gatekeeper, you need to fulfill some quite stringent rules, let's say that. A gatekeeper is then a digital platform with at least 45 million users, a month across several EU member states, which has an annual turnover in the EEA of at least 6.5 billion euros in the last 3 financial year, or an average market cap or equivalent of at least 65 billion. That's the basic. And then it also then needs to provide a so-called central platform service. And the central platform service is defined in the proposal. It can be a social network. It could be a video sharing platform. It could be cloud computing, advertising services, those kind of background platforms. And also an app store could be a central platform services. And if you fulfill these rules, then you are considered to be a gatekeeper. And then you're covered of specific, what we call ex ante rules. And they're provided in Article 5 and 6. And Article 5, one could call like black clauses, that is clauses that need to be abide by these gatekeepers. While Article 6 is also actually you need to abide by if you're a gatekeeper, but then the European Commission also had the possibility to actually make them specific for the specific gatekeeper. So they can take an individual decision actually to harden the obligation put forward in Article 6. And I will go through these clauses, hopefully, even though I need to do it quick in the following slides. The potential fines for violating the rules are high and can amount to 10% of the undertakings or the gatekeepers' global turnover. And in the event of systematic infringement, the Commission actually may require like structural actions, so the breaking up of the company. As a competition lawyer, I normally deal with competition law, but there's a difference here in this proposal compared to competition law, and that is that there's really no efficiency defense. You cannot go forward and say, well, this is actually creating a more efficient service to a lesser price, which actually should be better for the consumer. That is not applicable as I understand the proposal. There's also a very general limited list on grounds of exceptions. So these are quite hard ex ante rules, and which a gatekeeper needs to abide by. If you take a general overview of these rules, which is provided in Article 5 and 6, it's the interesting thing, I think, taking a step back, is that they cater to, or the main idea seems to be to create competition downstream or on neighboring markets. There are some rules which deal with directly platform to platform competition, and that's especially in the media market and the search market and so on. But generally speaking, what the proposal is trying to do is opening up this platform and letting them know that they need to follow some fairness rules when it comes to downstream competition. They can just not enter a neighboring or downstream market and use the power of the platform. And that is actually the aim of the rule. And you can divide them up. I've divided them up here in blue, orange, grayish, and yellow. And they are a little bit different. They deal with interoperability, mobility. If we take the blue ones, orange is more bundling and self-preference, so prohibition against that. And then we have yellow. If we go down to that is more about lack of transparency, also actually catering more to the media market. And the interesting thing, if we look upon them in more detail, they also are. You can find the source of many of these prohibitions or many of these rules, and this is my suggestions. I mean, I wasn't involved drafting this proposal, but if you take 5A, for example, which is prohibition for gatekeepers not to combine the personal data that they collect from their own platform service with personal data from other services, and that is a little bit. Addressing the problem we've seen with this in the German, in Italian Facebook decisions, where Facebook were accused of combining personal data from the Facebook services, but also from other services that they had access to that personal data. There's also prohibition against price parity clauses and MFN, so most favored nation clauses. That caters to other sort of investigation in cases which we've been dealt with against Amazon, for example. We talk ebooks, but also this quite large investigation in Booking.com, which the different national competition authorities looked at, which is called Booking.com. And what we see now is actually then a proposal to actually regulate this and not use then the competition law to try to prevent at least wide price parity clauses. There's also prohibition against steering clauses and exclusivity clauses, and that deals with cases like Google AdSense, where Google had starting with an exclusivity clause saying that if you put ads on our platform, then you must foreclose your own website to competing search engines. You cannot use ads from their services. We have also some Swedish cases which deals with exclusivity. Bruce is one case, which was an aggravated gym app, where if you were connected to that, you cannot put your gym on any other sort of app. You can only have it on Bruce. And the same thing with online pizza, reference to other sort of restaurants. There's also prohibition against bundling, and there we have Google Android, where if you had one app from Google, you needed actually to have 10 others. There's also a prohibition or rules against for price transparency regarding online advertisements. Article 6 also have a grand list, let's say that, of different sort of prohibition. There is a prohibition, for example, against side loading. And customer must be able to access and download and use apps from business users directly. You cannot prohibit them if you have an app store, for example, and provide that it should only go through the app store. There are also rules which cater much to the media market and advertisement services. And that's, for example, there's access to gatekeepers' performance measurement tools. And that is the tools that these platforms have, especially Google and Facebook, where they can provide to a customer, say that, well, if you put an ad on in our ecosystem, we can also actually check whether that ad is successful by certain techniques. And now that technique actually need to be open to competing advertising services, which could be a Swedish platform like Bonniers DN or Svenska Dagbladet or Aftonbladet. So there's a number actually of prohibitions here, which I think I need to skip a few, but then continue a little bit. So, and if you compare the proposal for the Digital Markets Act with other sector-specific regulations, there's of course other sectors which we specifically regulate to create competition. For example, the electric market. And it's quite interesting to see the similarities between the DMA and those regulations and also the differences. One question is quite clear. The application of DMA is a very legal tool. I mean, you need to fulfill these rules if you're a gatekeeper. If you don't do it, then that's a violation. There's no, you don't need to actually identify that competition is restricted either by object or effect. There's also, as I said earlier, there's no efficiency defense. So even if you can provide arguments that this is actually much better for competition, it's actually boosts competition, that is actually an argument that the Commission cannot take into consideration. And as I said, there's a limited grounds for exemptions under the rule. You need also to know that competition law is also always available and can be applicable even though the DMA is not applicable. Also, if we compare it a little bit to competition law and also, for example, the EU telecom regime, which is sector-specific regulation, the DMA has this notion of gatekeeper. And if you fulfill those rules, then the DMA is applicable. If not, then it's not applicable. And that implicitly implied it only caters to really large platforms. In the EU telecoms regime, you need to fulfill the rules. Or you need to be identified as a significant market power, as having significant market power. And always when we've used the EU telecom regime, significant market power also always imply that you're almost always that you're dominant under Article 1 and 2. In the DMA thing, I don't think that it's not as common as if you're a gatekeeper that you also are dominant. You need to make an individual analysis whether you're dominant or not according to competition law. Also, the DMA puts a lot of burden on the gatekeepers. They need to notify when they fulfill these rules to the Commission. The presumption is then that everything is applicable to them, and they need actually to provide evidence against that. And they also need actually to make suggestions how to fulfill this rule in Article 5 or 6. While if you take the telecom regime, the burden is actually on the national authority to show whether there's a violation or not. And also the EU telecom regime, it's decentralized. It is the member states, and it's often a national authority, so Post- och telestyrelsen, for example, in Sweden, while the DMA, the idea seems to be that you have the European Commission that is going to regulate these gatekeepers. Another one, which perhaps is not so, it's not going to happen, but it's at least a risk, let's say that, is that you need to, if you're a gatekeeper, you also need to notify every acquisition you do under the DMA to the Commission. And it could be a way actually to try to get those acquisitions to if the gatekeeper purchases a smaller firm, for example, to get that inside the door to the European Commission so they can actually review that too, that merger. Which is normally not available to them, so they need to go through the National Competition Authority, and there's a procedure for that. But the DMA could also actually have implication when it comes to mergers or share purchases and other sort of asset purchases. Good. I think I stopped there because I probably talked for way more than 10 minutes now, but
not way more, Björn. And
okay.
Thank you very much for this very enlightening introduction to the DMA. And without further ado, I will introduce Rupprecht on the virtual scenes. And please, Rupprecht, share with us your views on the DMA.
Sure, thank you so much. I'm going to show some slides too. And I wish to sort of put what Björn now introduced so well to us sort of a bit into perspective of what's going on. Before that, let me thank you, Vilka and SNS for the opportunity to speak and discuss with you. I think that's a European project, and it's very important that people from different countries act together to see what's coming out of that. So this is the German perspective a bit now. You will see that, you will sense that once in a while. I wanted to bring up the question again, just very briefly, why we do all this. And I want to bring you to the maybe a bit wider issue. What does that have to do with, say, small and medium-sized enterprises from Sweden, from Germany, from the member states? Is this just a GAFA thing? So Google, Amazon, Facebook, Apple, Microsoft, or do we have to worry, or do we need to do something beyond the Digital Markets Act? I think that's important if we sort of discuss platform regulation in general. And what you see on this first slide here is the declaration of power, or the manifestation of power by Google. What you have on the slide on the left side is the Google click-through rate per ranking. So what this graph actually shows is that the first search results on the first page in a Google search ranking is clicked by 28.5% of all users. And you see how that figure decreases, and the lower you are in the ranking, no one actually, or less people actually click on your website. And that's sort of what's happening. The number one in the Google search is the number one in competition, is the one getting this information, the commerce or whatever you have on your website through to the customer. And if you're on the second search page, you basically don't have a chance. Now, what the real power of Google is that Google has a market share, and that is the second slide, of more than 90% in globally. So within the European Union, the figures are similar to this one. So 90% of people do their internet search with Google. So, and if you take these two things together, you know how powerful, how enormously powerful the Google search algorithm is. It is for many people the gateway into the internet. It is the only way for you as a retailer, for you as a company to present your stuff. People won't find you if you're not on one of the two first ranking in that search question for 90% of users. This is our definition of near monopoly or power. This is the infrastructure, the backbone of our internet commerce. And today everything runs via the internet. I think it's important to have that in mind. These companies that we're discussing, the GAFAs, the gatekeepers, they have an enormous power. They form the backbone, the infrastructure of the internet. Now, this is a graph that shows where that leads to. It leads to incredible liquid means that they have. This shows the cash equivalents, and marketable securities of the big companies, Microsoft, Apple, Alphabet, the mother company of Google, Amazon, and Facebook. And just for reasons of comparison, I took two German companies, Siemens and BMW. I refrained from taking Swedish ones, just to show what they have as cash in their pockets. And the gap is enormous, which means if you're a believer that money can buy power, can buy market shares, can give you sort of access, etc., we should worry. And that is what stands behind this Digital Markets Act. Now, one final slide to get you to deprive you of sleep in the coming nights. This is a slide that shows what happened when Amazon and other companies, but with Amazon as a platform core, declared they would venture into healthcare. The shares of traditional healthcare companies plummeted by 5 to 10%. After the announcement that Amazon will enter the market. So the disruptive force is incredible. Market expectation is that platforms will rule your business, whatever business you're in. I mean, healthcare is not really something where we would instantly say this is the classic B2C platform commerce like Facebook showing pictures on the internet or something. This is a traditional business that at first sight does not have a lot to do with the platform business of Google and Amazon, but still markets expect that if Amazon enters that market, they can platformize that market, and traditional companies are driven out of it or become dependent on the platform that runs that. And that is sort of the danger and the big thing that we are discussing when discussing the Digital Markets Act. How does the platformization, how do digital ecosystems completely change our economy, and not just in the business of, say, some media companies that no longer sell newspapers, but in the field of traditional businesses. Now, we have antitrust for that, but as Björn has already pointed out, we do a lot there, but this comes too little, this comes too late, there is too little achieved by the remedies, and that's why we sort of approach this matter with new models of intervention. This is a decision that we still have to take. As Ilinka said in the beginning, we are now discussing the draft, and the draft that the Commission put forward is a regulatory proposal. So we submit these companies to regulation. Just sort of for your taking choices screen, there are other proposals on the table. Germany, for instance, took the way of strengthening competition laws, staying in the realm of efficiency defenses and the other issues that Björn already discussed. While in the United States, we now have a tendency to be even tougher, if you may say so, breaking up companies. You know, there is a proposal to break up Facebook that is running in the courts now. Other proposals in the United States seem to go into that sort of structural separation as well, while the EU has this Digital Markets Act proposal with per se rules that are for all digital gatekeepers ex ante there. There is another proposal running in the United Kingdom where the government tries to seek, or the competition authority tries to seek, individual codes with these gatekeepers. So not having a big legislative piece, but trying to debate what are the obligations for each individual gatekeeper. So these are different models that we may look into. And since I said this is still a draft, what if you want to take influence on that? And we have Håkan with us, who is influencing this probably with the Swedish government. So what are the key questions in my view, that still need to be spelled out? And I think the first really important question is, what do we want from the digital economy? How far are we? How far do we want these platforms to run the business? Are we happy with that because they're so efficient in reducing transaction costs? Or do we have other values? Do we have other ideas how we organize things in a digitalized world? The second question is, is this just cosmetics or does it really help something? I think with the obligations that Björn put forward, there are some that can be very powerful, others are maybe not so powerful. And we have to really look into the details of that, what will change in practice. Third question is the EU Commission alone able to handle that? You can have perfect rules, but if you don't have the person to enforce that, you should sort of work on that and change the enforcement structure. The fourth question is, can a company go to court in Malmo or elsewhere and sue a gatekeeper, or is that only a matter for competition authorities? I'm personally someone who is very much believing in courts saying, I want to take this company to court if I can. I would wish for such a private enforcement system. And finally, the final question, of course, is always, will the DMA hinder innovation? Will it stop Google and Amazon from inventing great things? There are some people who put forward that argument. I'm not a believer in that. I think that innovation is not hindered by the proposal now on the table, but obviously we need to keep that in mind, what will change in the data economy. Now, one final question is, what is important for small and medium-sized enterprises? They will be on the receiving end as business users if they use these platforms. But I want to sort of, just as an idea, as an impulse for what may even be regulated on a national Swedish level, give you one final input, and that's this slide. For many European countries like Sweden and also Germany, what is the next big step is not so much the consumer business as we see it with Facebook or where consumers interact, but the industrial appliances, the B2B sector, where the strong industrial players who ruled sort of the European economy over the past decades now sort of move into the digital age. And we see this happening all the time with smart homes, with smart factories, with predictive maintenance. Just to give you one example, if you want to repair a car, you nowadays need access to the operating system of the car, to the data of the car. That is something similar to what the gatekeepers do in the consumer field. This now happens with other companies in other fields. If you run a smart factory that is completely digitized, it's important that small and medium-sized enterprises get access to the smart factory, that they know how they can run on the interfaces. And that's something that is not regulated under the DMA because Google and Amazon and Facebook are not yet sort of strong in this business, luckily, sort of, but it is coming up, this sort of integration of ever more services on a databases into ever more industrial fields. And in my view, it's important that we take two ideas that are also a bit in the DMA, namely standardized interoperability and access to data in a meaningful, in a helpful way into our legislative agenda, maybe on a national level. I don't see that on the EU level at present, not so much, but we should keep that in mind, that it is important to think beyond what the GAFA companies, Google, Amazon, Facebook, are doing into the industrial, into the B2B context. Interoperability and access to data are the two fields that we need to have a look on. Thank you so much. I leave it at this, Ilinka.
Thank you very much, Rupprecht. And I will get back to you in the final panel discussion. But for now, I would like to welcome Håkan Hillefors, the government's representative in this webinar on the screen. I think I can hear you, but I can't see you yet. Yeah, there we are.
There is.
So,
thank you.
Very welcome, Håkan. And of course, we are very curious to hear from you. First of all, where in the negotiation process are the member states right now? And then, of course, also, what can you tell us about the Swedish government's position on the DMA?
Well, thank you. And first of all, thank you for inviting me to this seminar. The negotiations are ongoing. There has been a summer break during the Commission holidays, the EU holidays, but the presidency tabled a second compromise proposal just the other week, which will be discussed now the coming weeks, starting this week. I think that the negotiations will proceed in rather high tempo now over the coming weeks. From a Swedish perspective, we basically support the Commission proposal. We have done that from basically the beginning when we analyzed the proposal fully. We do believe that problems that occur regarding competition in this market, need to be addressed faster than we can do today, basically. We also believe that it's positive to have harmonized or common rules in this area. The companies, the services, and the markets are cross-border, and thus having the same legislation all over Europe is probably beneficial for all parties in this. Due to that, we also believe that the Commission is the right body to enforce this regulation. Of course, in cooperation with national authorities, but the Commission should be the overall governing body here. I think also that further on, we need to have clear lines between the DMA and national rules that perhaps already are in place, for instance. Rupprecht spoke about innovation. This is extremely important for us as well. It is important that the rules that will be put in place doesn't hamper innovation, or also doesn't hamper the will to invest in these markets by the companies, both the gatekeepers, of course, and also companies downstream.
Is there a risk now with the proposal as it stands that this will be the case?
We don't believe that, as it's been put forward by the Commission, but this is something that we need to be observant with during the negotiations, we believe.
In May this year, Germany, France, and Netherlands published a common position paper, and they brought up that they would like to see more power from the member states in relation with the Commission. What is the Swedish stand on that? Do you think that the proposal is fine as it is?
Yeah, as I said, we basically are fine with the Commission proposal. I mean, we're a small member state, and due to the cross-border nature of the markets and the services in this market, we do believe that the Commission is best provided to be the enforcement agency. As I also said, of course, this should be done in cooperation with national authorities, but and here I think that the Commission proposal also is fairly balanced in what it proposes that the national authorities should do. We don't, as it is right now at least, propose a larger involvement by the national authorities than the Commission proposal.
And what do you think? Will the Council reach a common position that they can sort of get public when? During this fall, or?
Of course we will reach a common position. When is harder to foresee. I think that the presidency will work towards a common approach in the fall. If that's possible, I don't know. We'll just have to keep on negotiating and see where we end up getting along. I think that there are a few issues that will be tricky-ish to solve during the fall, but I'm certain that we will get there in the end, either during this presidency or a coming presidency.
Thank you very much, Håkan. Now I would like to invite Pamela up on the virtual stage. Pamela, as I said in the beginning, you have a very long experience of competition law, both from the business side and also from working for the European Commission. And what are your reflections on what you've heard from Björn, Rupprecht, and now also Håkan?
Yeah, thanks so much. And thank you for inviting me to the seminar, and also to my co-panelists for their insightful comments going before me. I have a few points. I think the first thing to press is that we don't exactly know. We don't know exactly the sort of the remit of the law as of yet. It has to go through Parliament, and it has to. The Council has to agree as well. So we don't know exactly. And I think the one thing I would like to flag is I'm a little bit worried. This is a very far-reaching proposal, but given the sort of political aspects of it, I'm a little bit worried that it might be amped up even further, and that would be problematic in my view, at least. But so the first thing is obviously it's difficult to say now what the effects will be because we don't know exactly what will be the law. So that's the first thing to remember. The second thing, and I think that was something that Björn brought up as well, is that this is a little bit of a different creature than we used to. Competition lawyers are fairly sort of simple minded creatures to some extent. We deal with competition law, and we're used to kind of dealing with issues that relate either to horizontal cooperation between firms or you have market power. Now, this is something where you don't actually have the necessity of market power for intervention. And I think the reason why the Commission is going that way is potentially because there are other reasons for the implementation of this law than only competition law, even though they flag that, and they need to flag that because it's that's the legal basis. But one issue here is also there's an underlying sort of democratic issue of these companies having a sort of a too large influence over our lives. Now that may be all good and well, but it's really difficult to use antitrust law and antitrust sort of principles in enforcing democratic issues. And I think that's something that makes life a little bit difficult here. And the third thing is obviously that was already raised, that's the issue of who will actually be sort of dealing with these issues. Will it be national authorities or the Commission, or potentially also courts? Now, if you look kind of from my perspective, where do I see the issues, or what will happen from a competition lawyer's perspective? I think the first thing, and that obviously depends on how the law is defined, is who will be gatekeepers. Now, that's fairly clearly defined in the draft regulation. But the difficulty I'm having is when this was discussed beforehand, it was a lot of, Rupprecht mentioned that, it's the GAFAMs. So we talk about the Silicon Valley companies, basically. But if you look at the definition as such, a little bit, it kind of depends, I guess, on whether or not they would fulfill core platform services criteria. But both Klarna and Spotify are sort of verging. They're not there yet, but give it a couple of years, they're not that far from it. And that's not Google, that's not GAFAM. That's the companies complaining about GAFAM. So I think the gatekeeper thing will certainly be an issue. And I think a second thing is the way that the regulation is built up, and I think Björn mentioned that fairly clearly, is that you have a gatekeeper definition, and once you kind of fulfill that criteria, you have a lot of responsibilities. Now, what you generally, as competition lawyers, we argue a lot about relevant markets and dominance. You're taking that out of the perspective, because once you kind of fulfill those criteria, you'll have to report to the Commission, and which means that potentially what Rupprecht mentioned about national proceedings, I wouldn't rule out that a lot of companies will try and go for that. But so that's also something. And then, of course, also, which is already a very contentious issue, that's mergers, because that's been discussed so broadly so far. I mean, did the Commission go wrong in Facebook, WhatsApp? Was it wrong that they didn't have the possibility to intervene in Instagram? And the way the Commission is moving towards kind of using the Article 22 powers in the merger reg, and the possibilities here, I think mergers is certainly something. So those were my kind of main points, if you will.
Thank you very much, Pamela. And I would like to invite Björn and Rupprecht also into the screen. And also I would like to sort of turn to you, Björn and Rupprecht. Now that you listen both to Håkan and Pamela, it would be very interesting to listen to your comments on Pamela's comments, sort of this the rules being also having this flavor of a democratic issue, and And also, of course, which you have been talking a bit about, but who will deal with the enforcement, and also the question, of course, of which companies will be defined as gatekeepers, both now but also in the foreseeable future. I was wondering, maybe Björn, you would like to start off.
Sure, I think the definition of a gatekeeper has been drafted so to catch those GAFA, which are present at the moment. And it reflects a little bit on the whole proposal. Which is also because it plays out a different sort of prohibition, plays out to different sort of cases of investigation going on at the moment. But I do believe, as Pamela and Rupprecht is implying a little bit, if we take the future a little bit into consideration here, with like Internet of Things and the smart cities, everything you have it, that's a whole new ball game, and it also originates from the 5G, which is the Ericsson thing, which they are giving to the world at the moment. I'm just a simple lawyer, but to me, I think one of the effects of that is that these silos, where we have large gatekeepers, which have their own ecosystem, not really perhaps integrating so much in between the different silos or in between the different ecosystems, that would probably go away. I mean, if you have a smart city, then Google needs to collaborate with Facebook or Amazon or whatever you have it. And what that implies, if we use the Digital Markets Act, and I think this is a big problem, and maybe not, it may be been overseen, is that then Google will become a business user of Amazon. And Amazon will be a business user of Google. And Apple will be a business user of everyone else. And what are we creating then? If we're creating actually a tool here, the Digital Markets Act, where they are allowed to share any data they want in between themselves. And I don't think they want to do that. I think they want to compete on that, because that is actually their, that's the goal. That's their new oil that they want to use to compete with each other. And also, I don't think perhaps that is the idea. The idea from the DMA is that we have small business users, national, European, if we want to be out, go out of the closet. And they are actually going to make use of these rules to be able to access markets, and then they cannot be discriminated or unfairly treated by large platforms. But be very wary that, yes, some of these small players might become gatekeepers, but also remember that the gatekeepers will become business users in the future. And then I cannot really oversee what effects that have actually, but that's one thing. Another thing I think we talked about innovation here. The proposal is extremely silent about making use of intellectual property rights. And in my world, there are also intellectual property rights that might be triggered here. I mean, of course, the database rights, must be triggered. You can see that the Commission has been thinking about that, because of some of this provision is very, really drafted in a way that you might interpret it, okay, you're not triggering the database right, you can pick up all the data from the database, but not, this is, here we see, if I were a lawyer acting on the behalf of these platforms, that is actually how I would try to prevent these prohibitions. I will make use of intellectual property rights, database rights, and so on and so forth. Yes, that was my comments.
I would like to, before turning to Rupprecht, I would like to bring Håkan in. Now, these 2 points, the intellectual property rights and also the gatekeepers also being potentially business users of other platforms. How are these points being discussed in the negotiations?
I can't really say how they are being discussed in
being discussed?
I know that for instance, intellectual property has been put up for discussion within this remit, not perhaps as much in the proper negotiations, but I know that the issue has been brought forward to us. I think that if I go back to where Björn started his reasoning, I mean, threshold values to identify a gatekeeper in this instance. I mean, threshold values are always a problem in legislation. Not just in this area, but in all legislation. As soon as you put threshold values in there, it will start steering company behavior. And I mean, this is not something that I think will be exclusive for companies in this market. I mean, it's a generic thing as soon as you put threshold values in this legislation. But then again, you need threshold values often. It's hard to define who will be hit by a particular piece of legislation without threshold values. Yeah, I mean, they go both ways. You can't really be without them, but yeah, you do know that they will steer behavior in the market by companies.
Thank you. And Rupprecht, what would you like to comment on from Pamela or Håkan's?
Well, first on gatekeepers, I think that the current debate is moving into the direction of limiting the application really to the GAFAM companies. At least that was my understanding. So in the beginning, we talked of, say, 10 to 15 to 20 companies. Now, my perception of the debate is more we're talking about these 5 companies, but maybe Håkan has better information than I have on this. At least that's what the European Parliament's rapporteur, Andreas Schwab, suggested in his report. Second point, who will deal with that? I fully understand your position, Håkan, to say we are a smallish we have a smallish competition authority as compared to the powers of the European Commission. My only fear is that one day the European Commission loses interest in this, maybe, yeah, or Madame Vestager is maybe no longer in charge, and some new commissioners thinks that these digital platforms should no longer be in the spotlight so much, and then it would be important to have a fallback option in the sense that national competition authorities, private enforcement, etc., can work, because I mean, the Commission currently plans to have 80 people enforcing that. I find that very courageous. If you think of only 5 gatekeepers, like 5 companies, with all their lawyers and economists and whatever they bring into the field, and 18 obligations in Article 5 and 6 of the current draft, they will have a lot of stuff to do, these 80 people, right? So I guess we need some support, and there is some support already provided for now, but it could be a bit stronger maybe. One point on what Pamela said, and also what you, Linka, said earlier, I think this is about democratic values, and this is no longer just about competition. I think that's something new. These companies run business models on network effects and with economies of scale that are different from what we have seen before in most markets. And wherever we have seen that in markets, that one company gains such an infrastructure position, we usually reacted to that with regulation, and regulation moves beyond pure efficiency concerns and moves into the realm of we want to achieve things. So if you think of telecommunication or energy regulation is about providing safe energy to everyone, and telecoms regulation is about securing communication between people, etc. And this is sort of, for me, very similar in this field. Of course, we are discussing democracy here. We are no longer just discussing, is it very efficient to act in the way they do? They do act in a pretty efficient way. I concede that. No worry, no, there's no point in challenging that. But the question is that really something that we see as the business models that we wish to see? And therefore, I'm always a bit hesitant to agree with people who sort of tend to see this as a piece of antitrust. It isn't. It is not a piece of antitrust law. It is not a piece of classic competition law. It is something new, and we have to come up with a new mindset towards that, even because we saw that antitrust law was not able to deal with these companies in a fashion, in a way that we see fit.
Pamela, would you like to respond to that?
Sure. Yeah, no, I agree with Rupprecht that we've gone beyond antitrust. I think the problem is that the sort of the root of the argument comes from the failure of antitrust. So you're trying to fix something with an antitrust thinking. And antitrust is, quite frankly, I don't think it's fit for that. And I think you should, I mean, we could have that discussion, but we shouldn't have it within the antitrust realm. It should be a broader discussion on democracy, rather than trying to sort of fix something and try to some extent, I guess, fly under the radar by saying this is a competition problem. I don't think it is. I think that discussion is much more difficult to have. Because
who should have this discussion? I mean, who would be the actors discussing this?
I think it would be. I think it would be fair that it's likely to be within, I guess, the Commission as well. But then it wouldn't be kind of spearheaded by competition law, an alleged or real competition law problem, but rather a democracy problem, if that's what they want to fix. That's. I think that would make more sense. In that case.
And I mean, you worked a lot with telecommunications, and can you see what can we learn from the regulation of that sector that might or might not have sort of bear some learning points for the regulating the internet economy? And also, I would like to ask why do you think that it's taking so long to do this proposal? I mean, why has it been unregulated for such a long time?
Well, I mean, on the first point, I think this is so different from the S&P's procedure under telecoms regulation, where you have to kind of define markets and you have national regulators going in. You have it's a very different creature. And on the second point, I'm not entirely sure I agree this has taken so long. I would say rather the opposite. It's kind of, in my world, it's like a big train running through Europe with an immense speed at the moment. I'm a little bit scared by it.
The regulatory train.
The regulatory train, exactly. I'm not saying GAFAMs are the train. I'm saying, but because I think this is an odd question. It is a different question from questions that we've sort of tried to answer through regulation before. And I think we're really rushing it, and rather the opposite than you saying it takes a long time, I'd say the opposite.
And I would like to ask, well, any of you, what are the sort of protagonists doing right now, the tech giants? I mean, you said, Rupprecht, that money can buy power, and I'm guessing that these platform companies are doing something in order to sort of have a say in how these rules will play out. Do you know anything about it? Are they already adapting? Are they trying to influence the process? What are they doing?
I would love to see Håkan answering this question and tell us how often he met with, or how often they tried to meet him in this process.
We do get a lot of proposals for meeting parties in this negotiation right now, both from both sides, basically, both downstream companies and of course representatives of gatekeepers. I mean, they wouldn't be doing their job if they were not in contact with us, and as well the other member states, governments, and the parliament, I presume. So of course we do get a lot of information from both perspectives, if I just reduce it to two parties basically here. So yeah, I mean, they are active.
And I would like to turn a bit to sort of the Swedish perspective, and I mean, maybe you, Håkan, but also Björn and Pamela, you have some insights on this. How engaged is the Swedish business community in the proceedings of this proposal and the upcoming rules? I mean, are they engaged? Is this seen as a great matter for the Swedish industry?
Of course. I mean, sorry if I just jump in and take the floor here, but I mean, when I say we do get contacted by a lot of parties, these of course also include Swedish interests and Swedish companies and Swedish organizations. So yeah, they're taking an active part, I would say.
Björn, would you like to chip in?
Ja, jag tror att tar vi ett svenskt bolag som är Spotify.
In English, please.
Oh, sorry. Yeah, sorry.
Even though it's the Swedish perspective, but anyway.
It's a Swedish perspective. If we take one Swedish company, which is Spotify, I mean, they've been fairly active in both in reference to the Commission and also in I think lobbying for this proposal, and including certain prohibitions inside the proposal. I think that someone from Google has actually raised their hand there, but my take on the GAFAs is that at least when I've been contacted, they seem also to be trying a little bit to protect their home market of the US. They don't want the DMA to be exported to the US. And there's a book by Senator Klobuchar, I think she about antitrust now and how to use it against digital economy. There's I see a lot of seminars in Washington, D.C. about in the pipeline about European DMA not be a good thing for the US market.
Pamela, I would like to hear your comment. You said that this is not going too slow, it's going too fast. What are your biggest worries about it going too fast?
I think it's the combination of things I've mentioned. First of all, that we're not rooted necessarily in dominance, which has always been something that at least competition lawyers have kind of liked to be rooted in. And the second thing is, if we're not there and we're trying to fix a problem that's really democratic, have we thought it through? I mean, these are to some extent very, very far-reaching obligations. And I think to some extent, I mean, I'm not on the sort of barricades to defend GAFAMs, but I think to some extent, I sometimes sense that people think, well, they're so big, they're grown into these giants. It doesn't matter if we chop off an arm, they'll survive anyways and kind of move on. And I don't think that's necessarily something I agree with and think is a sound sort of legal or democratic principle.
Thank you. I believe that will be this vivid image of a giant with a arm chopped off will be the concluding remark. And I think that we have only scraped on the surface of this issue, and we for sure from SNS will get back on this on further occasions. And I would like to thank Håkan and Pamela and Rupprecht and Björn, and also of course you in the audience. I'm sorry if I didn't see the raised hand, but we will have more opportunities to discuss that. And I would like to finish off with a happy news that we will soon be able to invite you back to our premises here in Stockholm for a live audience on seminars. And the first seminar that we plan to have a live audience is on the 11th of October. And then we will have Tobias Krantz presenting his inquiry on research infrastructure. So until then, and maybe also in the meantime, I hope to see you soon again, and have a nice afternoon.